So in this video, I want us to shift our attention to nuisance. So what is nuisance? Nuisance is an unlawful interference with the person's use or enjoyment of land or some right over or in connection with the land. And here we have the case of Bamford versus Stanley of 1862. And the facts of this particular case were that the defendant burned bricks on his land, creating smoke and fumes that drifted onto the plaintiff's property. And the issue was, did the defendant's activity constitute an actionable nuisance? And the rationale in this particular case was that the court held that a rule of give and take applies, but where an activity causes substantial interference with the neighbor's comfort, then it amounts to a nuisance. Now, there are three types of nuisance. The first type of nuisance is private nuisance. Now, a private nuisance protects an individual's proprietary interest in land against a number of things: against physical damage to land, against interference with enjoyment of land, and against interference with rights over land. So that private nuisance is a wrong, which is a civil wrong. The second type of nuisance is public nuisance. And the public nuisance affects, the public or a section of the public. It is a crime, but an individual may sue in tort if they suffer special damage. And a good example is blocking, a public highway. The third type of a nuisance is a statutory nuisance. Now, this one is created by statute, particularly, the Environmental Protection Act of 1990. It covers, smoke, it covers dust, it covers noise, and it also covers fumes. And it is controlled, by local authorities, and it can also overlap with other torts. So that this nuisance cannot actually overlap with, trespass to land, it can overlap with negligence, it can also overlap with Ryland versus Fletcher liability. So who can sue in private nuisance? You see, private nuisance protects interest in land. Therefore, only persons with propriety rights can actually sue. And this includes owners, it includes tenants, it includes, persons with exclusive possession. But lodgers, guests, and family members without propriety rights cannot sue. If you look at the case of Marlon versus Lesky, the facts of this particular case were that Mrs. Marlon was injured when vibration from the defendant's premises caused, a toilet cistern to fall. And the issue was, could she sue in nuisance without propriety interest? And the rule is that only persons with propriety interest in land may actually sue. And the application of this particular case was that Mrs. Malone was merely a licensee and had no ownership interest. So the conclusion of this case was that her claim actually failed. Now the principle is that a mere occupier without propriety rights cannot sue. If you look at the case of Hunter versus Canary Wharf, the facts of this particular case were that the claimants complained that Canary Wharf interfered with television reception. Some claimants were owners, others were family members and lodgers. And so the issue in this case was, who was locus standi in nuisance? And the rule is that only those with propriety interest or exclusive possession can sue. And the application of this particular case was that the owners could sue, and so family members and lodgers could not sue. The House of Lords also held nuisance does not protect, personal injury. The conclusion of this case was that claims by non-proprietors actually failed. Now, the principle is that propriety interest is mandatory. So who can be sued when it comes to private nuisance? You see, land liability may attach to a creator, an occupier, and also a landowner. Now, let's look at the first person who can be sued, and that is the creator. Okay. Now, in that a person who positively creates nuisance is liable. So that liability arises from an act, not an omission. The second person who can be sued is the occupier. Now, occupiers are liable for their own nuisance, employees' nuisance, adopted nuisance, and also continued nuisance. If you look at the case of Sally Deanfield versus O'Callaghan, the facts of this particular case were that local authority placed a pipe on the defendant's land. It became blocked and flooded the defendant's land. The defendant knew, and used it. And the issue was, did the defendant adopt the nuisance? And the rule is that an occupier who adopts or continues nuisance is liable. And the application of this particular case was that the defendant used the pipe and benefited from the pipe. And so the conclusion was that he was found liable. Now, the principle is that knowledge plus continuation equals liability. The third person who can be sued is the landowner. Now, landowners are generally not liable after parting with possession. However, the exception is authorized nuisance, that is, existing nuisance before lease. If you look at the case of Tetley versus Chitty, the facts of this particular case were that a council leased, land for go-karting. Noise disturbed residents, and the issue was the council liable? And the rule is that a landlord authorizing nuisance is liable. And the application of this particular case was that go-karting necessarily created noise. And so the conclusion was that the council was found to be liable. You see, the principle is that authorization creates liability. Now let's shift our attention to private nuisance. See, a private nuisance is an unlawful, indirect interference with land, with the enjoyment of land, and rights over land, which is, unreasonable. So what are the elements of private nuisance? You see, here the claimant must prove a number of things. The first thing the claimant must prove is indirect interference. And examples of indirect interference include smoke, smell, and noise. Now, there are no direct trespass. The second thing the claimant must prove is physical damage, in that there must be material damage. If you look at the case of St. Helens Melting Company versus Tipping, the facts of this particular case were that industrial fumes damaged the claimant's trees. And the issue was whether physical damage constituted a nuisance. And the rule is that physical damage to land is actionable. And the application of this particular case was that the trees were physically damaged, hence the defendant was held liable. Now the principle is that physical damage automatically supports nuisance. Now let's look at interference with the enjoyment of land. Now this includes noise, smell, smoke, and offensive businesses. It does not include personal injury. Now let us look at test of unreasonableness. Now courts usually balance competing land rights. The factors the courts consider include locality, sensitivity, malice, duration, and public benefit. Now let's look at the first factor, which determines unreasonableness, and that factor is locality. In that the nature of the neighborhood matters. If you look at the case of Sturges versus Brigman, the facts of this particular case was that a doctor complained about factory noise, and the issue was whether factory noise was a nuisance. And the rule is that what is nuisance depends on locality. And the application of this case was that residential medical area required, silence. So the conclusion of this particular case was that the defendant was actually held liable. Now the principle is that what is nuisance in one place may not necessarily be nuisance in another place. If you look at the case of Gillingham Borough Council versus Medway Dock Company, the facts of this particular case were that a dockyard, was converted into a commercial port. So noise complaints arose. And the issue was did planning permission alter locality? And the rule is that planning permission may change character of the area. And so the application of this particular case was that the area became commercial. So the conclusion was that there was no nuisance. The principle is that character of locality can actually evolve. Now, and by that I mean you can have a residential area which actually can turn into a commercial area. The second factor determining unreasonableness is sensitivity, in that abnormal sensitive property may defeat claim. If you look at the case of Robinson versus Kilvert, the facts of this particular case were that heat damaged delicate brown pepper, and the issue was could claimant recover? And the rule is that defendant not liable where claimant's property is abnormally sensitive. And the application of this particular case was that ordinary pepper would not be affected. And the conclusion was that the claim failed. Now the principle is that unusual sensitivity defeats claim. If you look at the case of McKinnon Industries versus Walker, the facts of this particular case was that gas damaged orchids. And the issue was sensitivity a defense? And the rule is that a claim succeeds if ordinary property will also be damaged. And the application of this case was that ordinary flowers will suffer too, and so the claim succeeded. Now the principle is that sensitive property may recover if ordinary property will also suffer. If you look at the case of Network Rail Limited versus Maurice, the facts of this particular case was that railway signals interfered with recording studio. And the issue was interference foreseeable? And the rule is that foreseeability may replace, sensitivity analysis. And the application of this particular case was that the interference was unforeseeable. And so the claim failed. You see, the principle here is that foreseeability is actually central. The third factor determining unreasonableness is malice, in that malicious acts may become a nuisance. If you look at the case of Christie versus Davy, the facts of this particular case were that the defendant intentionally banked walls to disrupt music lessons. And the issue was whether malicious conduct was nuisance. And the rule is that malice can make lawful acts unlawful. And the application was that the conduct was actually deliberate. So the conclusion of this case was that the injunction was granted. The principle is that malice makes interference unreasonable. The fourth factor determining unreasonableness is duration, in that longer interference increases likelihood of nuisance. And a good example is repeated loud parties, even though one of acts may still qualify. The fifth factor determining unreasonableness is public benefit, in that public utility may be considered, but it is not decisive. If you look at the case of Adam versus Hassel, the facts of this particular case was that a fish and chip shop caused steam and smell, and the issue was could public utility excuse nuisance? And the rule is that public benefit does not justify private nuisance. And the application was that the residents suffered substantial interference, and the conclusion of this particular case was that the injunction was actually granted. Now the principle is that public convenience is not a defense. Now let's look at interference with interest in land. Now the protected rights when it comes to interference with interest in land include right of support, right to light, easement, and right of way, so that interference constitutes nuisance. Another thing we should look at is the natural condition of land. Now, originally, landowners were not liable for naturally occurring nuisances, but modern law imposes duty where risk is known. If you look at the case of Leakey versus National Trust, the facts of this particular case was that natural subsidence caused rocks to fall onto the claimant's property, and the defendant knew. And the issue was, could landowner be liable for natural hazard? And the rule is that duty exists where risk is known and preventable. And the application of this particular case was that the defendant knew, and failed to act. And the conclusion of this particular case was that he was held liable. Now, the principle is that knowledge of natural danger creates duty. If you look at the case of Holbeck Hall Hotel versus Scarborough Borough Council, the facts of this particular case were that a hotel collapsed due to coastal erosion, and the issue was whether damage was foreseeable. And the rule is that duty depends on foreseeability, and the application of this particular case was that the collapse was not reasonably foreseeable without expensive survey. And the conclusion of this particular case was that there was no liability. So the principle is that there is no duty without foreseeable risk. So remember, to prove private nuisance, you need, proprietary interest, you need indirect interference, you need damage or interference, you need unreasonableness, and you need foreseeability. For defenses or issues, remember sensitivity, remember locality, and also remember public benefit. Remember also malice, and do not forget duration. And who can sue? Owners and tenants. And who can be sued? Creator, occupier, and authorizing landlord. So here is a quick memory formula of what we've covered so far. In nuisance, remember PIDUF. P for proprietary interest, I for indirect interference, D for damage or discomfort, U for unreasonable conduct, and F for foreseeability. So if it is your first time here, make sure to follow this channel and to subscribe for more legal lessons. My name is Biketi, and see you in the next one.